Come on, please grab some food, and I'm just going to start us with the introductions. People trickle in so we don't run out of time. So we're very excited to be having this first event. The Animal Law Program launched on Friday, and it's such a pleasure to have John Adentire and Raffael Basel talk about their new book, Animals and the Constitution, which I'm going to pass around so you can take a look. We also have some discount flyer codes for it as well, which we'll pass around. But let me just give everybody an introduction, including our commentator, Will Kimlicka, who's joining us as well. So John Adentire is at the Queen Mary University of London School of Law, where he's a senior lecturer and fellow of the Institute of Humanities and Social Sciences. Raffael Basel is the University Assistant Professor in Public Law at Cambridge Law Faculty and Fellow of Jesus College, co-founder and co-director of the Cambridge Center of Animal Rights Law. And the book that John and Raffael have written together is Animals and the Constitution Towards Sentience-Based Constitutionalism. And it's been published recently by Oxford University Press. Our commentator is Will Kimlicka, who is professor and Canada Research Chair in Political Philosophy at Queen's University, and co-convener with Sue Donaldson of the Animals and Philosophy, Politics, Law, and Ethics Research Group at Queen's. She's been running now for quite some time. Thank you all for participating in this launch. And as I mentioned, this first event of our new program. It's still part of the Animals in the Law and Humanities Working Group series for people who are we've been running that group since 2013, so it's still going on, that group, but it's going to be housed now within the Animal Law Program. Okay, so I'll turn it over to John and Raffael to give us an overview, and then Will is going to give his commentary. I'm going to pull out a couple of law themes and points, and then we'll have a discussion Q&A, which we're recording this event, but the Q&A, we won't be posting the recording of that. So just for your, you know, information. That's great. Raffael, do you want to tee up your slides?
Will do. There we go. Can everyone see that?
Yes.
Excellent. Well, thank you so much, Angela, for the kind introduction and for having us, and congratulations to you and the team on the launch of the Animal Law Program. It's really a very exciting accomplishment, and I look forward to all the great things that you guys have in the work. So well done to you and everyone else who's been involved in this. So really amazing for the entire field, really. And just a note too, if I start to doze off at some point, my wife and I've got 10-month-old twins at home, and they're keeping us awake at night. So maybe I'm not going to be at my sharpest today, but I'll try my best. So it's a real pleasure really to be here. John, obviously, you know, I'm quite envious because you can be there in person. Unfortunately, I'm just joining online, but nonetheless, we really appreciate the opportunity to talk to you all about our new book that came out this year with Oxford University Press, Animals and the Constitution Towards Sentience-Based Constitutionalism. For those of you who aren't in the room, you can find the promotion code, that discount code that Angela mentioned, on the slide here. So if you type in AUFLY30 in the OUP website that's mentioned there, it won't work on Amazon, obviously. And then you get 30% off. It's still not the cheapest book, I'm afraid, but at least it takes down the price a bit. Or you can ask your libraries to order a copy of the book. That would be much appreciated too. Right, so here's an overview of the contents of the book. We have divided it into two parts. The first part explains what the status quo is of constitutionalism. We call it anthropocentric constitutionalism. It's focused on human beings and centers on their interests and privileges their interests over those of non-humans. We then make the case for why this should be abandoned and replaced with a more capacious version of constitutionalism. We call it sentience-based constitutionalism. That's the first part. And the second part of the book is then devoted to spelling out how this exactly would work. So we focus on 4 central constitutional principles: fundamental rights, proportionality, the rule of law, democracy, and we try to rethink those principles in a sentience-based way. So in other words, what would it mean for democracy to be here not just for human beings, but for all sentient animals? What would it mean for fundamental rights to protect the key interests not only of human beings, but of non-human animals as well, etc.? So we are dividing the presentation into 2 parts as well. So I'm going to speak to you briefly about part 1, explaining the what and the why. And John will then zero in on some specific topics in part 2. We won't really have the time to go through all of them, but I'm sure that in the discussion we can pick up on some of the topics that we didn't get to cover here. So, anthropocentric constitutionalism. I said that this is the status quo of constitutionalism. So if you look at constitutional practice around the world, so what do constitutions look like? How are they being interpreted by courts? And also constitutional theory and constitutional scholarship. So what do the thinkers, believe is the case with regard to existing constitutions? We will find that they are very much centered around human beings. So they are anthropocentric, they privilege human interests. And the first chapter looks at 4 key ways in which this anthropocentrism manifests itself in legal systems around the world. So we don't look at just any one jurisdiction, the UK or the US. We look at examples from around the world and try to show that, look, this is happening everywhere, basically. So it's a slightly more detached theory that we are proposing here. So the first thing you'll find is that constitutions around the world only give human beings intrinsic value, or only recognize human beings' intrinsic value. So for the most part, there are some exceptions. These constitutions do not recognize non-human beings, and obviously we're focusing here on animals, as having intrinsic value worth protecting by the law. Connected to this is the idea that animals are subject to the use paradigm, as it's sometimes called. So in other words, animals are resources that we can exploit. They are a means to our ends, be they, gastronomical ends, be they, entertainment or, medical ends that we're putting them to. Animals who are here for us to use. That is how constitutions view them. And that obviously is very different in the case of human beings, who are considered as having intrinsic value and cannot be, used as mere means for others' purposes. Then this is enabled by the fact that animals are ownable things, so they are property that can be owned by legal persons, such as human beings and corporations. And then lastly, what we find in legal systems around the world is that they contain human-centric concepts. So this can be either concepts that are sort of explicitly human-centric. So if you think of the standard of the reasonable man, for instance, in tort law or other areas of law. But there are also concepts that are neutral on their face, but that are interpreted in practice in ways that are anthropocentric. If you think, for instance, of legal person. Legal person itself, the term doesn't limit it to human persons. Indeed, as I just mentioned earlier, corporations are legal persons as well. But the concept is interpreted or conceptualized in such a way that non-human animals so far are excluded from its scope. So these are 4 manifestations of anthropocentrism in legal systems generally. But then if we look at constitutions specifically and constitutional practice and theory specifically, there are 4 additional ways in which we can see that human centrism. So the first one is that only human beings possess fundamental rights. There's some corporations that have them too, but arguably it's humans' interests that are protected through corporations' fundamental rights. So animals have no fundamental rights. Some believe that animals have something called, a thin right or a simple right, but they sure don't have fundamental rights. Certain very limited exceptions in some jurisdictions that, are very exciting and that John and I can, speak about if someone's interested. But for the most part, we can note that no fundamental rights for animals. The proportionality principle, which is applied in legal systems around the world, with some exceptions. The US doesn't explicitly recognize it. I'm not sure about Canada, actually. I'd be keen to hear about Canada. Proportionality being basically a principle that applies to sort of legal relationships generally, but specifically also in context of human rights that conflict with, say, the public interest or with other rights. And we believe that proportionality should be, at work in the context of animal rights as well, but currently it isn't. And we can see that in the fact that when a human right clashes with an animal's interest, or animal's thin right, if you want to call it that, then even trivial human interests will win out against even the most important interests that animals have. Then the rule of law does not extend its protection to animals either. It only protects human beings. And John, I think, is going to talk later about the specific sort of vision of the human being, or basic idea of the human being that underpins current rule of law conceptions that lead to the exclusion of animals as well as some human beings, in fact. And then lastly, democracy in constitutions around the world. The demos is considered to be a human people. Democratic practices and indeed conceptions tend to exclude animals. Animals are not considered, worthy of democratic consideration, let alone participation. What the chapter ends with is it looks at some quite promising developments in certain constitutions, Switzerland being an example, Brazil, India, and others, that seem to give some constitutional level protection to animals. But we look at those protections and we show that actually they're a step in the right direction, but they're far from delivering sentient beings what they are due, at least as far as we're concerned. So what are they due exactly? And that brings us to the second chapter, where we make the case for sentience-based constitutionalism. So we need to abandon anthropocentric constitutionalism and we need to adopt sentience-based constitutionalism. But why exactly do we need to adopt sentience-based constitutionalism? Maybe to some people in this room at least, it will be pretty obvious. But we do think it's worth making the case, and we do so by digging into the theoretical foundations, if you like, or the justifications behind what's sometimes called classic constitutionalism, or really the model of anthropocentric constitutionalism that is dominant today. And this is a model that emerged in the 18th century with the French and American revolutions, that basically distanced themselves theoretically from the idea and practically from the idea of divine right of kings, and that tried to find a different theoretical foundation for the constitutional framework. And that foundation was found in the idea of the hypothetical consent of the governed, right? So this is broadly the idea of the state of nature, that is a hypothetical state that we leave by consenting with one another to create civil society through creation of a constitution and further laws. Now, why do we reject this legitimating principle? Because everyone, I'm sure, agrees that hypothetical consent it sounds pretty good, doesn't it? It means rule by those who are ruled. So what could possibly be wrong with that? Well, we think there's a problem with it. It creates a legitimacy gap, as we say. Why does it create a legitimacy gap? Well, it creates a gap because this principle here cannot explain why many of those who are actually governed by constitutions are subjected to the treatment and treatments, sometimes very exploitative treatments, that they are by constitution. So they're governed, but we can't really justify to them why they are being governed. So why exactly does it exclude some beings? And I'll say in a moment, who's exactly excluded? Well, look at this. It says hypothetical consent of the governed. The presupposition here is that you can give consent to a sort of governance structure that is being debated or being proposed to you, albeit hypothetically, but it requires consent. That, in turn, requires, the possession of a certain set of mental capacities. You need to be able to understand what's going on here. You need to perhaps be able to understand constitutional concepts. You need to perhaps have, a sort of an idea of different possible alternatives, which one is best to pursue. Maybe you want to have and, be able to have an idea of the common good that you want to pursue. So, in other words, they're quite, demanding capacities here at stake. Now, of course, it says hypothetical consent of the governed. So, someone might say, well, can't you just assume that, everyone has these capacities? But that's a bit of a challenge as well, because the idea of hypothetical consent still assumes that we're assuming that these beings are, rational, they have the relevant mental capacities, but and now comes the part where I talk about, who's being excluded here. This excludes many, if not most, non-human animals who don't have the relevant rational capacities to understand, those constitutional, frameworks that are being debated and consented on. But not just does it exclude non-human animals, it also excludes many human beings who lack the relevant capacities, who cannot consent to, governance structures, even hypothetically, because the assumption that, well, what if they were rational and therefore consented just transforms them into entirely different beings that they are not. So we think this creates a big problem because it only really justifies rule for the very few who can give hypothetical consent. So how do we propose to overcome this? Very briefly, our alternative principle is that of all governed interests. So in a nutshell, we say that due concern needs to be given to the interests of all governed sentient beings, right? So if due concern is given to the interests of all governed sentient beings, then the legitimacy gap is filled. Now, very briefly, what does this mean? Due concern we define as respecting the basic interests and the intrinsic value that sentient beings have. So it's about respecting basic interests, not trivial interests, but basic interests of those who have intrinsic value. It doesn't actually apply to all sentient beings, but only those who are governed. By governed, we mean you are under the effective control, either your habitat maybe, or your body, your limbs are under the effective control of public authorities. Only if that applies to you are you actually governed by a state. So we say, for instance, Canada, being such a vast country, that there will be animals who are not effectively governed by the state because they live in the remote wild. So those beings, they wouldn't actually fall under our principle, but nonetheless, we believe that very many would. Now, this wraps up sort of the overview of why we think anthropocentric constitutionalism needs to be replaced with sentience-based constitutionalism. And I'm now handing over to John, who will speak to you about what's next. And John, you can just tell me when to skip to the next slide.
Yeah, I'll be very brief. I'd like us to hear from Will and Angela. So in the second part of the book, we talk about some constitutional principles, fundamental right, proportionality, the rule of law, and democracy. And we show how in this sentience-based constitutionalism framework, these principles of constitutionalism should be rethought or reframed. I'll just use as examples in the fundamental rights chapter. We argue that existing catalogs of fundamental rights can, in principle, be interpreted or be read to protect the rights of non-human animals. So, in essence, we don't need a new Bill of Rights. Okay, we can use the same, or in most cases, we can use the same rights that apply to humans, and we can extend them to animals. And the rationale here is that many of the interests that humans are actually shared by animals as well. Many of the features that characterize fundamental rights, such as the fact that over time, the subject of right holders has been expanded. So, for example, in the United States, we say in the book, the holders of fundamental rights were property owning white men, and then over time, the subject holders of fundamental rights expand. So there are many characteristics of the practice of fundamental rights that justifies our view that in the suitable conditions, in the ideal conditions of a sentience-based constitution, the same catalog of rights can be used for humans and non-human animals alike. And in the book, we give a few examples. We consider the right to life, the prohibition of torture and degrading treatment, and also the right to freedom. So if you want to know more, you should read the book. Raffael, if you skip to the next slide, please. And after, we also have a chapter on the rule of law. And here the argument is that we should reconceptualize the idea of the rule of law in a sentience-based constitutionalism. The rule of law is no longer about guiding the conduct of people, as Joseph Raz made this argument very famously. Okay, rather that we should reconceptualize the rule of law as really restraining arbitrary power. Okay, this view of restraining arbitrary power is also within the academic tradition of the rule of law. Okay, so we don't really need to reinvent the wheel, so to speak. And so in this chapter, we argue that this shift towards a different concept of the rule of law is able to afford due protection to the interests of animals. And so the rule of law also protects animals. We can talk about more of this concept in the Q&A, but for now, I would like to hear from others as well.
Okay, that's great. So we got a note in the chat there that it's a bit distorted, the audio in the room, but unfortunately our mics seem to be nailed down to these desks. I can't really move them. But anyway, hopefully we can just speak up, and hopefully that would be good. Okay, Will, would you like to do your comments now?
Yeah, sure. Thanks. Thanks, Angela, for the invitation to be part of this, and thanks to John and Raphael for the book, which is it's a great book and a real contribution to the field. And I agree with the basic, motivation for the project and with many of the arguments. But I just want to focus on one possible disagreement. So I'm just trying to share. So can people see my slides?
Yes.
Yeah, okay. So I want to focus on the democracy chapter because that's the one that most intersects with my own experience as a political philosopher. And it's the one chapter where I probably have the biggest potential disagreement, but that's what I want to explore, is whether we just are using different words, and is this a semantic disagreement or a deeper substantive disagreement? So in political philosophy, when we think about the Constitution, we typically think about it in what I call a dualist framework, which is to say that political philosophers just think of politics and law and justice and rights as operating at two basic levels. There are certain rights that accrue to us in virtue of our status as citizens, and other rights that accrue to us in virtue of our intrinsic moral status as human beings. So at one level, there are universal human rights, which we have simply in virtue of our common humanity. And so those include things like bodily integrity, the right not to be tortured, the right to rescue. You don't need to be a citizen to be owed those universal human rights. But there are other rights in the Constitution that are limited to those who are viewed as members of the demos. And two core such membership rights are the right to a fair share of the benefits and burdens of social cooperation, which are typically operationalized in the form of the welfare state, some scheme of social rights, and the right to steer the future of society, which is operationalized through democratic rights. And those are, in I think, virtually every constitution around the world, not seen as rights that accrue simply in virtue of one's common humanity, but are membership rights. Yeah, so constitutions talk about all persons have the right to X, all citizens have the right to X. Those are two different levels in constitutions. One can criticize this, and there's a long tradition of cosmopolitanism which which is critical of it. But I think this kind of dualist framework is deeply entrenched in legal systems around the world. And so it raises the question, do we want or need some version of this distinction for animals? Would a pro-animal constitution also take this dualist form? So just to give an example of what this means, this is just let me briefly describe the framework that Sue Donaldson and I formulated, which tries to extend this dualist model to animals. So on our view, domesticated animals, almost by definition, should be seen as members of our society. That's just literally what domestication means, bringing animals into our society, into the domus. And so we argue that domesticated animals are clearly entitled to those two membership rights, including democratic rights to shape the terms of the social order and a right to a fair share of the social product. So for example, there should be public health insurance for domesticated animals. By contrast, we view wild animals as forming their own self-governing societies. So they should be protected by universal rights, the right not to be tortured or subject to degrading treatment and so on, but they're not members of our society because they're members of their own self-governing societies. And we should think of our relations with them as international relations rather than domestic co-citizenship. So we could think about something like treaty relations with wild animals, as some indigenous societies have done historically. So again, there are cosmopolitan critics of this dualist framework. Alistair Cochrane famously rejects our attempt to distinguish membership rights for domesticated animals from self-government rights for wild animals. He thinks we just need a single kind of monistic theory of rights for animals. But yeah, Sue and I propose a dualist framework. So I'm interested in the question of whether John and Raphael's theory of sentience-based constitutionalism, is it dualist in the relevant sense? And I found it a little hard to pin down in the book. So there's some passages which suggest that it's skeptical about the need for a dualist approach to animal rights in the Constitution. So in their discussion of fundamental rights, for example, they don't explicitly, at least, distinguish universal rights from membership rights. And I think you saw that in the presentation just recently, that the category of fundamental rights is used without distinguishing universal rights from membership rights. So in our view, democratic rights are fundamental rights, but they're fundamental membership rights. So, I mean, the category of fundamental rights, I think, needs to be disaggregated into both. There's fundamental universal rights, fundamental membership rights. But John and Raphael don't explicitly draw that distinction. And in other passages, they also say that it's a virtue of their approach that it doesn't require categorizing animals, whereas a dualist framework clearly does draw these categories of, for example, domesticated versus wild. So there are passages that suggest that it's skeptical of a dualist framework, but I think at the end of the day, the book actually does bring back dualism through appeal to this all-governed principle, which puts a lot of emphasis on the question of whether animals are subject to effective control. And that seems to me effectively to operate as a kind of membership criteria, that if animals are subject to effective control, then they qualify for membership rights, not just universal rights. That's, I think, how I understand the argument. And so on that, although they don't really use exactly that terminology, but so if that's right, then the implication is that domesticated animals are almost always going to be members and have membership rights because they are, again, almost by definition, subject to effective control. But whether wild animals, for John and Raphael, whether wild animals are members is going to depend on whether they are subject to effective control. And so they say this quite explicitly in the book, that it's an open question whether a particular group of wild animals will or will not be seen as members. And we answer that question by examining the level of state control over them. And so they say, for example, that if a state declares a conservation zone, then that would put wild animals under the effective, or could put wild animals under the effective control of the state, and then they would be seen as members who would have membership rights. Okay, I'm not a big fan of this all-governed criterion. I don't think it's the right way to think about dualism. So I think we can see this in the human case. So leave animals aside for the moment, that the all-governed principle, on its own at least, can easily become a justification for colonialism. So think about France and Algeria. France colonized Algeria, and it was subject to, people criticized colonization as being undemocratic. So at one point, France proposed that it would extend the franchise to people in Algeria, and basically on the grounds that, well, we're exercising effective control over Algeria, that'll be legitimate. We can legitimize our control over Algeria if we give democratic rights to people in Algeria. But extending citizenship to people in Algeria and under those conditions is not a victory for democracy. It's not a victory for justice. It's just licensing and legitimizing colonialism, because, the Algerians have a right to govern themselves. And that's prior to it should be prior to the all govern test. So I think we need to step one step back, and we need some prior account of who has the right to govern themselves, who should be subject. And we can't start with the question who is subject to the effective control of a state. We need to ask who should be subject to the effective control of a state. And on our account, wild animals, we have no right to be exercising effective control over many wild animal communities. And so Sue and I would think about conservation zones differently. On our view, they're not a step towards incorporating wild animals into the demos. They should instead be seen as a step towards recognizing their rights of self-government. And so for John and Raphael, wild animals should be seen as having, self-government if they are not subjected to, there's a mistake there on the slide, that for John and Raphael, wild animals should be seen as self-governing if they're not subjected to the state. But I think that's backwards. I think wild animals should not be subjected to the state because they have prior rights of self-government, and that we want a theory that makes sense of that possibility. And I just don't think the all-govern test gives us that. So here's my suggestion. As I say, I think this could be a relatively minor tweaking of the story, or it might be a deeper challenge. I'm not quite sure, but this is how I would think about a more explicitly dualist account of sentientist constitutionalism. So I would try to, I would encourage a more explicit distinction between universal rights and membership rights. I think we need that in both the human and the animal case. And if we did that, I think that would strengthen the rights of animals along two fronts. First of all, it would give us a stronger basis for insisting on membership rights for domesticated animals. And that means we could defend not just meeting their basic needs, because there's some passages in the book that suggest that that's kind of the limits of the rights of domesticated animals, is just meeting their basic needs. But Sue and I want to insist that they have a right to a fair share of the cooperative social product, their claims of distributive justice in relation to the society that they have helped to build with their labor and their blood. And conversely, in relation to wild animals, drawing this distinction between universal rights and membership rights would also give us grounds for insisting more strongly on rights of self-government. And it would limit the extent to which the state can just continue to colonize wild animals by asserting effective control over them, including through conservation. So that's my suggestion about how we might build on the idea of sentientist constitutionalism, but make it more explicitly dualist. Thanks.
Okay, thank you so much, Will. And Raffael, I don't know if you want to say anything, or John, do you want to say anything immediately, or do you want to just mull and hear the other thoughts?
Yeah, let's hear.
Okay, that sounds good. Okay, so I would say, I kind of am jumping in here to bring up some legal themes, just because Will was saying, Angela, you got to say something about the law, because otherwise it's going to give a distorted sense of the book to just talk about the political product. So that's kind of my assignment here. I will say this book is super clearly written. Like, it's really a pleasure to read. It just, it says what it's going to do, it does it, and then it sums it up, and then it builds up to the next part of the argument. And so I really want to congratulate you both for writing such a good, clear book. It's not easy to do that. In terms of the project, I have to say, I think it's a very interesting combination of, sort of, at some moments I thought, oh, they're really going for like very kind of minimalist criterion for like moral and legal consideration by using sentience. And, as many people in the room and in the audience know, sentience is really kind of becoming, like it has been for quite a long time, I think, the sort of the litmus test for, okay, you have moral interest, moral worth, and then maybe, legal and legal consideration as well. So I think harnessing that is very, it's a really good idea. And one of the things they mentioned in the book is the 2022 Animal Welfare Sentience Act, looking at, how in the UK, an animal sentience committee. This is something that I know people have heard a lot about that, but it would be great to maybe hear a little bit more about that as well, just because in Canada we don't have that. But the sentience criterion, so it's in a way it's very modest. It's really just that ability to suffer or to feel positive or negative emotions. So there's got this bar for animals, which is always good for non-animals because, we're talking about so many different species. Some species are going to be able to meet bars, some aren't. So sentience, I think, it seems to be the very well accepted way of doing this. But on the other hand, the project, is almost like the highest bar you can possibly set out in terms of law and politics. The constitutionalism is a very high bar. So when I was reading it, I was very much having this experience of, wow, like we're not just talking about legal person here, which is, commonly discussed. And a lot of people have kind of written about that and weighed in on that, including me, because it's sort of hard to resist. But really, the constitutionalism, that's the part that I think people are, going to sort of look at and want to engage with the project, because it is so ambitious. So I think that is just sort of, that's worth pointing out, that it's sort of at the same time, it's doing something that's like easy barred entry, but then also giving us this, really like, that's the golden ticket, right? Is constitutional protection. And then the book does, a really nice job of not being grounded specifically in any one jurisdiction. It's sort of giving this more general, analysis. But that is one thing that I was wondering about as I was going through, whether like the implementation of sentience-based constitutionalism, is it going to differ and depend on, which nation state you're in? So are we talking about Canada, where we have living tree? I can kind of imagine something like this being more implementable versus US, where their, intention, the framers, impossible to ever make your constitution. That's it's going to be very different in that context. And then in the UK context, which you both would be really familiar with, is, an unwritten constitution, but now you guys have lots of written parts too. So is that sort of something where you imagine it's the, where it's going to meet the practicality different based on the nation state? I'm not sure. But, Raphael, you asked about proportionality in Canada, and, we really have that very strongly with our Charter of Rights and Freedoms. So, we've got all rights listed, like the right to freedom of expression, let's say. And then if there's a law that impinges on it or limits freedom of expression, what the courts do is they say, okay, there's a violation of that right, but is it saved under Section 1? And Section 1 says you can impinge on those rights if it's justified in a free democratic society. And we really have a system that's very much like what you guys are outlining in the book, where you ask about what's the aim of the law. Is it the least drastic way of doing that? And I think, what we call it, the small bites, in the multiple attempts at the test. Ours is very much like that too. And I think, we're probably in keeping with a lot of countries on that point. But I guess in terms of a few things that jumped out at me, at one point you quoted Jess Eisen, who was also, I know has been, working and involved with you guys on this project along the way, and rethinking constitutionalism. And she says at one point that you quote her as that you have to do more than just simply widen the circle of dignity-bearing entities. And so you are on board with that. But there were multiple points in the book where I wasn't really sure what that difference was. Like, what was that extra thing that was not just widening the circle? And maybe that's something you could respond to. How would you characterize what that something more is? It's everyone who is sentient, but is there something special in there for non-human animals? Because I can imagine Manisha Dekka saying, that's depending on what that is, it depends very much on species. And some people are going to have an easier time meeting that than others. I mean, using sentience is, pretty low bar for that. But if it's not just widening the circle, how would you say, well, we're not just widening the circle? Like, I would say that. And then in terms of Anna Peters also jumped out to me at one point. You quoted her on the small growing number of states elevating concern for animals to the status of constitutional provisions, and that's very cool. And Jess Eisen's work on that and Chris Insell's work on that is really helpful to look at, like, what states have done it. But again, are we going to have a lot of differences state by state, depending on whether you have a jurisdiction where a constitution is liable to be amended, or jurisdictions where there's new constitutions? Obviously, that's the best case scenario. Thinking about the political feasibility of this, I feel like because constitutional status is above even personhood status, depends on where you're looking. Because in the US right now, and Matthew Liebman is working on a paper about this, you've got all these states that are passing anti-personhood statutes. So they're basically saying, you have to be a human being in order to get the personhood statute. So, I mean, something like, getting constitutional protection even higher than personhood what would that look like in that framework? So, I think it's really important to have the general theoretical framework, but also to be thinking about some of those jurisdiction specific issues. Okay, those are my thoughts, and I don't know if we want to respond to anything or open it up to people.
Should we respond to these two maybe, and then we can open it up to the room? Just my memory is limited.
Absolutely.
Okay, let me get first up. Thanks. So thank you, Will, for your very insightful comments. I think you're absolutely right. Like in the book, we don't do sufficient justice to this distinction between equality of rights, what you call universal rights, and citizenship rights, and that is because we had an additional chapter that didn't make the end. Part of the reason we're supposed to have a chapter on sovereignty, okay, which will answer this question of right to self-government, right? Who is entitled to the right to self-government? And as our excuse, you will see that in the you may remember in the conclusion there is a maybe 2 or 3 paragraphs where we contend with this very question, but we do not settle for any particular option. In fact, we start meandering and start talking about federalism, whether federalism is a way to conceptualize our relationship with animals. That is, we can still, even if a government has effective control over wild animals, the extent of their rights or the extent of their entitlements will depend on the autonomy, natural autonomy of these communities. So, for example, a group of crows may be more or less self-sufficient than, I don't know, a group of domesticated cats. So there is some awareness of this issue, but you're right, that is not something that we tackle front. Though I'm sure Raffael will have a few other clarifications and caveats put on this. So let me turn to Angela's comments. Yes, in the UK there is a animal sentence committee, and as far as I know, I haven't followed it closely. The remit of this committee is to consider the potential impact of legislation on certain sentient animals, right, as defined in the statute, and they can make some recommendation. I haven't really seen whether much work has come out, so maybe Raffael can has looked at this more closely. But in any event, it's not very binding. This is very far from what we are picturing in the book. And you raised a lot of implementation and political feasibility questions regarding the book. Neither Raphael or I are experts in political science or applied law, because we are mostly theorists and comparative scholars. But what we really pride ourselves in having done through this book is to build a lodestar, like a guiding set of principles that those that are more practically oriented can use as a blueprint towards a more just constitution between humans and non-human animals. So yeah, many of the ways in which this sentience-based constitution will be implemented will, of course, vary depending on the local traditions and the history and the path towards sentience-based constitutionalism. We don't imagine that there's only a single path towards this. We do say something to finish on whether we have widened the circle sufficiently, a moral circle who is entitled to constitutional rights or constitutional protection, not just through rights, but through the other principles like the rule of law and democratic participation. We do say that we think that sentience is a sufficient, though not necessary condition, exactly as a response to some of the scholars that you have mentioned that take a different approach to legal or moral subjecthood, such as Manish Dika, that I think is more about vulnerability, and Jess Eisen as well. So we are aware of this literature, and part of our strategy of not being exclusive to only sentient beings is actually as a way to accommodate these different foundations.
Yeah, thanks a lot.
Do you want to add?
Thanks, John. Yeah, there's just a few points that I'd like to touch on. And first of all, thanks to Will and to you, Angela, for taking the time to read the book and for your really thoughtful reflections. It really means a lot. It's a great honor. So a couple of things that John didn't quite mention. So it's true that, to your first point, Will, that our book doesn't really, make clear where we land on this sort of distinction between, more dualist ways of thinking or indeed more cosmopolitan ways. To the extent I think that we don't, spell out this distinction between universal and citizenship rights, it is because of our cosmopolitan intuitions. I think it's fair to say, I think John would agree with me on that. That's not to say, as John intimated, that there aren't ways in which the theory might be developed that would accommodate group distinctions more than perhaps the book does at the moment. So the idea of a more federalist sort of way of thinking about wild animals versus domesticated animals can take us some way in that direction. But certainly when we talk about giving due concern, protecting the basic interests, such as by protecting fundamental rights of beings with inherent value, we do mean all beings who are governed by the Constitution, and we don't, in principle, foresee a distinction between, a sort of a narrower group within those who are governed and the larger group of all those who are governed. So to that extent, I think, yes, we are, more cosmopolitan. As far as your criticisms of the all governed interest principle are concerned, I think they're very, very powerful and challenging, and I'll have to think more about them. But here's some tentative reactions. So, can our theory justify colonialism? Two thoughts on this. So first, we don't take a stance on when effective control is sort of ought to happen, right? So we don't make an argument for humans should, have even more effective control over the lives of animals. As you said in, I think your second point, a theory is necessary to, make the case for when and when not is, governance over animals justified. That's not our theory. We don't pretend to want to answer that question. What we do is we take for granted the fact that billions of animals are already effectively governed by states. And then we ask, okay, so what would it take for that governance to be legitimate? But we don't really take a stance on the question, well, would life outside the effective control, be better for an animal? We don't discuss that, and we agree that a robust theory in that is necessary, but it's not ours because it's not its purpose. Second, on the colonialism point, it seems to me there's a difference between pretending to give due concern to a group's interests and actually doing it. So to the extent that effective control over a territory does, lend some legitimacy if it's done right, then yes, it does have to be done right, and it wouldn't allow for the domination of a group and the exploitation of a group. So to that extent, our theory would not justify, something like, sort of France's colonialism over Algeria or its, animal equivalent. Let me see. So that's as far as this goes. I think that covers the other point as well. And let me now also address just one point that Angela's made. So on Jess Eisen's point, yes, I think, her work as always is just terrific. And it's true, I think, that we don't widen, not just the circle, but our understanding of how animals relate to constitutions and vice versa, in as maybe radical a way that Jess does and Jess proposes. But nonetheless, I don't think ours is just an exercise of let's, redraw the lines without rethinking the way we approach animals and the way we approach legal institutions. So it's perhaps a bit of a middle ground what we do. Just to give you an example in the context of the democracy chapter that Will's alluded to and has analyzed, we say that animals are indeed political agents in informal contexts, right? In maybe, public spaces, in private interactions with human animals. And that means we need to be listening to them, and we need to allow them to participate in, the sort of the democratic law formation process. Now, this involves animals and their experiences. It gives them choices in ways that go beyond a mere sort of widening of the circle that says, well, take into account the interests of animals, but you don't really try to open the door to understanding their own world. So we do go in that direction. But at the same time, we also say that in formal political contexts, like, voting at the ballot box, human representatives are still going to be needed. So perhaps when it comes to that, we're a bit more conservative and don't perhaps, sort of go as far as Jess would, but a bit of a middle ground there that hopefully goes somewhere in the right direction. But thanks so much for your thoughts there.
Okay, super, Raffael, thanks. That's kind of what I was trying to get at in terms of, what is the more than in the widening of the circle. No, that's great. Okay, so let's open it up to the audience, both here in the room and also on Zoom. I think we've not that many people, so if you want to raise your hand on Zoom and just unmute yourself, I think that would work just fine. So do we have any takers? Yeah, Mohammed.